So Donald Trump filed numerous motions to dismiss in the Mar-a-Lago document case for his willful retention of national defense information. I want to discuss two of these motions to dismiss, which actually read more like a confession than a motion to dismiss, and whether this was accidental or arrogance or just throw mud on the wall and see what sticks, or just trying to buy time and get an interlocutory appeal with the 11th Circuit, which is surely going to rule against Donald Trump regardless of what Judge Aileen Cannon does. I mean, what Donald Trump's saying in these two motions are just kind of absolutely as absurd, and essentially an admission that he did what he's being charged with. And one of these is a motion to dismiss the indictment on absolute presidential immunity grounds. I covered that in another hot take, so I'm not going to go through all of that again. But the other motion to dismiss that I want to talk about is Trump's motion to dismiss the indictment that's being prosecuted by Special Counsel Jack Smith in the case before Judge Aileen Cannon, based on the Presidential Records Act, based on the PRA. You kind of combine these motions, and what Donald Trump is saying is that sometime while he was in office, he took this national defense information, he took this classified these classified documents, this highly sensitive information, again, which could include nuclear secrets, war plans, information about military capabilities of other countries, and Trump basically saying that he would have declassified them without any declassification memos, but he would have declassified them and then declared that these documents and this highly sensitive national defense information were personal records that he owns and he controls, thereby stripping the United States government of access and control over them such that it becomes converted into his own property, his own personal property. So when I say, well, this seems like it is a confession, it's because what Donald Trump is saying is that his conduct was intentional, that he intended, right? When we talk about criminal conduct, there has to be the element called the mens rea, the mental state, the intent. And so by filing these motions to dismiss on absolute presidential immunity grounds, but more specifically pursuant to the Presidential Records Act, what Donald Trump is saying is, yes, I had the requisite intent. I looked at this national defense information. I looked at the nuclear secrets. I looked at the war plans. I looked at the military capabilities, and I said, mine, I want them. I sent them to Mar-a-Lago, and by doing that, while still in office, I'm subject to absolute presidential immunity because I did it while in office. And number two, it's now my personal property. Donald Trump cites that Clinton socks case. You know how we would always talk about, it's the socks, the Clinton socks case. Total garbage. I mean, this Clinton socks case was a case brought by one of Donald Trump's legal advisors who's not a lawyer, who never was a lawyer, but runs the right-wing organization called Judicial Watch. Again, so this non-lawyer, total idiot, named Tom Fitton, brought a lawsuit against the National Archives back, I think it was in 2010 or 2011, to try to get access to President Bill Clinton's personal notes from 1999 when Bill Clinton was writing an autobiography for when he would leave the office. So because, well, first off, Judicial Watch lost the lawsuit. It was a district court case, so this is not precedent. So Trump cites this case like it's precedential, like it's a circuit court opinion or a Supreme Court opinion or even persuasive authority, which it's not. But to the extent it is persuasive authority, it cuts against Donald Trump because the very first off, the case says, you, Tom Fitton, you random dude, you can't sue NARA to try to seize personal property of Bill Clinton from 1999 and 2011. Like, this is a frivolous garbage lawsuit. What are you filing? So that's kind of the first thing. But in any event, these are personal notes of President Bill Clinton. That's why it's personal property. And under the Presidential Records Act, if Trump were to have personal notes, if Trump were to take personal photographs, if Trump were to paint a personal painting. Of course, he can't do that. If he were to do things that were personal and then you designated your personal property as personal, you can do that, but you can't convert government records into personal property. You don't take a wand and go, aha, those war plans, abracadabra, you are hereby my personal property. You military capabilities, abracadabra, you are, what do they say in Harry Potter? Abracadabra. And they don't say that in Harry Potter, but you're now my personal property. You belong to me. The Presidential Records Act says you can't do that. It says the opposite of that. So not only is Donald Trump going to lose these motions, regardless of what Judge Aileen Cannon does, in many ways, you may want Judge Aileen Cannon to make the wrong decision and rule in favor of Donald Trump just so she can get removed from the case, because it would be so grossly egregious if she did that. But then again, you've got Judge Aileen Cannon. But again, Trump is admitting that his intent was to take these records, send them to Mar-a-Lago, because he claims it's mine, mine, mine. Now, of course, there's no paper trail for any of this because Trump's lying and making it up. I mean, this is his telepathic declassification concept where he didn't have to tell anybody. Just by doing it, he declassified. Just by doing it, he turned it into personal records. It makes zero sense at all, because if you believe that this was all your personal records, then why would you return some of them and then hide others? Like when you returned some of it back in like January of 2022 and you said, here, I'm returning it. So why wouldn't you just keep all of it and say, whoa, this is my personal records. I don't owe you anything. You would think that would be the response again, because this is all a sham and it is all a lie. But again, if I'm Special Counsel Jack Smith, I'm like, okay, you've admitted it. You admitted your intent was to turn this into your personal property. Let's take a look right here what it says. It says, Donald Trump, this is the PRA motion, Presidential Records Act motion to dismiss. Trump respectfully submits this motion to dismiss the superseding indictment pursuant to the Presidential Records Act. First, the PRA conferred unreviewable discretion on Trump to designate the records at issue as personal. As such, Trump's possession of those records was not unauthorized as alleged in counts 1 through 32. Second, the PRA's exclusive remedy for records collection efforts by NARA is civil in nature and forecloses criminal investigation. Therefore, as with counts 1 through 32, the remaining counts charging Trump in the superseding indictment failed to state a claim under Rule 12b-3-5 of the Federal Rules of Criminal Procedure. Accordingly, pursuant to the Presidential Records Act, the superseding indictment must be dismissed. None of that is true. Everything he says there is just not only false, but like egregiously so. Goes on to say, Special Counsel concedes the genesis of this case dates back to at least the tail end of the Trump administration itself. The office alleges in the superseding indictment that Trump caused scores of boxes, many of which contain classified documents, to be transported to Mar-a-Lago. The superseding indictment makes clear that this decision and the related transportation of records occurred while Trump was still in office, alleging that Trump caused boxes of records to be packed and shipped in January 2021 as he was preparing to leave office. Trump departed the White House prior to 12 p.m. on January 20, 2021, and as such, he is alleged to have made the decisions concerning the documents at issue while he was the commander-in-chief. It goes on to cite the Presidential Records Act, but tortures what it actually says. It then claims that Trump's possession of the documents charged in 1 through 32 was not authorized under 18 U.S.C. because Trump exercised virtually unreviewable Article 2 executive authority to designate records as personal, when, as alleged in the superseding indictment, he caused materials to be transported out of the White House. Trump made the challenge designations while in office as the constitutional superior of the archivist, Trump says. He goes on to talk more about the PRA. And then Donald Trump basically says that he did it. He took it. He made these designations of our classified info that are identified in 1 through 32 in the superseding indictment, and they belong to him now. So go away, and court shouldn't have to review this. That's actually what he's saying right there. But look, I mean, if you take a look at the superseding indictment and you just go and look at counts 1 through 32, just take a look at them, what these documents are, because these are highly sensitive, highly classified national defense information. Here, I'll pull it up right here just so you can see what Donald Trump is claiming as personal. Top secret, number one, document dated May 3rd, 2018 concerning White House intelligence briefing related to various foreign countries. 2, document dated May 9th concerning White House intelligence briefing related to various foreign countries. 3, undated document concerning military capabilities of foreign country and the United States with handwritten annotation in black marker. 4, document dated May 6, 2019 concerning White House intelligence briefing related to foreign countries, including military activities and planning foreign countries. 5, document dated June 2020 concerning the nuclear capabilities of a foreign country. 6, document dated June 4, 2020 concerning White House intelligence brief related to various foreign countries. 7, document dated October 21, 2018 concerning communications with a leader of a foreign country. 8, document dated October 4, 2019 concerning military capabilities of a foreign country. 9, undated documents concerning military attacks by a foreign country. 10, document dated November 2017 concerning military capabilities of a foreign country. 11, undated document concerning military contingency planning of the United States. 12, pages of undated documents concerning projected regional military capabilities of a foreign country and the United States. I go on. You get the point. This is what he's saying belongs to him now. He took it and claims that this is personal. Look, this is so patently absurd. This should not be a Democrat and a Republican thing. This is just a criminal, treasonous, traitorous thing. It is what it is. You see it right here. I read for you his arguments. I'm showing you what the documents are and as they are described as, and he's saying that this belongs to him. That's so entirely improper. There's no way to defend that unless you want to turn America into Russia and you want to have a Putin instead of a democratically elected president. There's no mincing words here, folks. Well, let me know what you think in the comments. I'm Ben Meiselas. This is the MeidasTouch Network. Hit subscribe. Let's get to 3 million subscribers together. Have an excellent day.
Love this video? Make sure you stay up to date on the latest breaking news and all things Midas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.